to get all cleaned up and put away.
Welcome.
Hello. I realized the last second I wasn't sure which one of us was going to start that.
No split screen today. We are here together in person.
It's so good to be back. It's been so long.
Yes.
But here we are.
I'm not used to it.
I'm hoping everything is working out because we don't really have a way of testing the sound when we're together. And also my signal is giving me this like connection is unstable thing, but I think the Wi-Fi is working just fine. Hopefully everyone can hear us. If you're one of our early arrivals, let us know if the sound is good, if you can hear us, and if the connection is stable.
Right. Yes. Please let us know in the comment section if you can hear us okay, see us okay. And today we got a cool topic for you. So in the past, we've talked about appealing for IHSS. We talk about that a lot. I'd say in recent months, it's been about other things, but cool to kind of bring it back around. And so we've talked about getting prepared for IHSS hearings and things like that. What documents seem to work the best when you're providing evidence. And so today we're taking a little bit of a turn. We're going to talk about maybe mistakes that some people make or things that you can avoid prior to the hearing or leading up to the hearing or being in the hearing itself, and things maybe what not to say, what not to do that can help increase your chances of actually winning an appeal, because we know how difficult the appeal process is right now.
So Cindy says, hi, Cindy. Glad to have you. Hopefully you're able to hear us. Let us know if you're not able to. Actually, if you're not able to, you won't know that I asked you to. So yeah. Hopefully all is good on your end. But yeah, anything that we need to announce or get into before we start our main topic?
Well, I think last week Teresa corrected us. We don't have any upcoming seminars or anything like that. So if you live in a certain area and you have a group or a place you want us to go to next, let us know. I think our last spot was San Bernardino, right? That was where.
Yep.
Okay.
And she told me the other day that we actually, weeks after the event was over, we were still getting signups for that event. We did make sure to take that off the website now. So there's no San Bernardino event happening right now. But yeah, it seems like a lot of people are still eager for something going on. So maybe a Zoom webinar, or maybe we'll come do a seminar in your area if there's a lot of interest for it.
Yeah.
And also, I think I mentioned this last week, if you know of any special needs gatherings, events where people, resource fairs, booth events, that you think would be a benefit for us to, let people know about our services, let us know. Send us a message on Facebook. We'd love to hear about that.
Yeah, please.
And one last thing before we get started on our topic, as always, be sure to give us a like, share it with someone follow us on Facebook or subscribe on YouTube, whatever. Especially if there's someone that who could use this information, who might want to learn more. Share this video with them.
Yep, please do. Helps us out a lot to kind of get more people into the stream, because this is live. We are live right now. So if it is not Friday at 12 o'clock on the 20th of June, then welcome to our page. You stumbled upon an old video or on YouTube, and that's great. We're glad that you're here. Dakota, are we ready to jump into our topic?
I think we are.
Chunk of people here now. So, all right. So we do have a little bit of some points that I think we might want to go over. So I think we should start maybe with the importance of this topic. Why would we be jumping to kind of a negative thing? What not to do when appealing IHSS? Yeah. So to start, why would somebody appeal? Why would they need to appeal IHSS? What is the purpose of it?
Well, I mean, to put it simply, your right to appeal, your right to due process, as they call it, is a very important part of not just IHSS, but any government support program like this. That sometimes social workers make mistakes, right? Sometimes they come to the wrong conclusion, or they don't get all the information, or whatever. And so it is a great thing that people can, when they believe the social worker made the wrong decision, argue their case to a higher authority, to a judge, can present their evidence against the social workers. And so it's a pretty vital part of the whole process that there are some checks and balances, that there's some oversight to make sure that the social worker doesn't have absolute authority. And so anytime that you think there's been a mistake made, and it can even be minor things, you have a right to due process and to appeal your case if you think they've made any kind of mistake.
Sure. Yeah. And I think that it's no secret now, right? There is a lot of chatter, especially here on Facebook, with, support groups for IHSS where people share their experiences with the appeals world. And we do that often as well. Dakota is very, very involved in the appeals world on that side. And we do see a lot of the challenges right now and how they've evolved. It's always been a very difficult arena to navigate. But even as advocates where we represent people formally or informally, rather, there's some really big hurdles that have to kind of be that you have to know about so that you'll have the ability to hurdle over them, right? Objections that the social worker might bring up in front of the judge, or maybe a statement or a question a judge may ask that sounds really harsh, but it's meant for you to say something that's helpful for your case. There's a lot of cool stuff that we can maybe go over. And so, one of the things I think would be good to start with is when to know when to appeal and when not to appeal. I think a lot of people will file an appeal simply because their social worker told them to. I think that happens often. And if not that, then somebody else told you to, or you recently learned that was an option. And so you want to be quick to appeal because you feel that it was wrong. You had some preparation work done. You were getting ready for your assessment. You applied, you got ready for your assessment. You presented something like protective supervision, which is going to be probably the most common category that's appealed for, at least for the people that watch these videos every week. Yeah. And you feel super ready. You go in front of the social worker, and the social worker maybe says some things that are just not in favor of protective supervision for your child or your loved one, where you're pretty determined and believe that according to the regulations that you read up on, or you have a friend who has protective supervision for their child, and you feel like, hey, my little Johnny should have this, right? And I felt ready. My evidence was there. I got a letter from the doctor that says he needs protective supervision. What more does the social worker need? The social worker is denying because they saw little Johnny grab a blanket in the middle of the assessment because they were cold. And they claimed that meant that they were self-directed, right? And it's the social worker didn't want to hear about the other behaviors like elopement or wandering into the street or, self-harming behaviors. And they came up with reasons as to why these things don't, qualify you for protective supervision, right? And so you're sitting here with this bubble of frustration and you want things to be made right. Well, Dakota said something really powerful that I've mentioned multiple times before. You said something, this was months ago. You said that, filing an appeal for IHSS, going in front of the judge, a hearing was a place where things should be made right. Justice is found. And that's just not how it is anymore. It's not really what it is. It's just this benefit's very subjective. The rules and regulations are very subjective. And everything kind of has to be perfect in order for you to actually present a really good case and win. Yeah. Especially if you're fighting for something like protective supervision. And so I think my first point here in this rant is not to appeal just because you're told to by a social worker or by maybe somebody on a support group or a friend or whatever. Yeah. Because I think there needs to be some sustenance behind before actually appealing. Like, do you get my point, Dakota?
I do.
Like
I think I would modify it slightly because I think, for us, what we do, we are very quick to ask for an appeal whenever there's something we disagree with. But what I would say is that we always keep the possibility that we may not want to follow through with doing the hearing in front of the judge. And there's a reason for that, because it doesn't cost you anything to ask for a hearing. It doesn't cost you anything to do the hearing other than your time. However, the reason that we sometimes will advise people not to proceed with their hearing, even after we've requested it and done all this work, is that the more times that you are denied by higher and higher authorities, the harder it is that you're going to get it changed in the future, right? So if a social worker denies you protective supervision, that's one thing. But if you then go to an appeal and maybe you're not quite prepared for it, you don't have good evidence like you're talking about, and you go through that whole process, go before a judge, and then the judge denies you, then the next time you have an assessment with your next social worker is so much harder, 10 times less likely that they're going to overturn what the judge said. Yeah, because they're going to come into the house, they're going to say, a judge said that this person doesn't need protective supervision. I'm not even going to think about it. I'm not even going to consider granting it. That's the kind of thing that happens. And so that's why, while I'd say, go ahead, ask for an appeal. You can do it quickly. That's fine. But do be prepared to look at your case as objectively as you can and say, is someone who, because this is the way it is, think of the judge as not believing a single word you say, right? Because they're not going to. If anything that you say goes against what the social worker says, there's any contradictions there, the judge is going to assume that you are lying and the social worker is telling the truth every time. So you need to look at your case with the lens of saying, if everything I'm saying is completely irrelevant, do the documents, do the evidence show that my child needs protective supervision or whatever you're appealing for?
Yeah, and I think that's a big challenge that a lot of people have, especially parents, when they read certain documents and they say, this is a slam dunk for protective supervision, and they present it, but then it ends up being many parts of that document or that piece of paper that actually goes against the regulations for protective supervision, and you didn't even know. You were like, wait a minute, the doctor wrote a letter and it said that he needs protective supervision, but then there's also things in that letter that go against the regulations, and all of a sudden that letter is now going to be used against the need. Right. And then pairing it with what Dakota just said too, like testimony of the social worker versus testimony of you, the parent or the loved one in the scenario. The judge will always know that you have something to gain here if you win your appeal, especially if you are the provider. The social worker does not, right? Allegedly. But
so I was going to say, Boblin brings up a thing, a kind of a point of what could happen in the opposite is that social worker took away the hours, she appealed, she won, which is great. We love that. And the judge, wanted to give even more hours if she could, and said ever since then, no social worker has taken away the hours. And that's exactly kind of goes to the same point I was making of once a higher authority has made a decision on the case, it's a much less likely that the next social worker or the one after that or the one after that, they're not going to want to go against all the people before them, especially judges.
That and Boblin, one, thank you for sharing that, by the way. Awesome. Congratulations. Way to go. However, your situation is a slightly, not unique, but different. So you had a removal of protective supervision or a removal of hours rather than necessarily a denial. Technically, it is a denial of hours, but if you have protective supervision, you have 200 plus hours a month, and you've had it for a couple of years, and then a social worker comes in and takes it away, that's a different type of appeal. It's still an appeal, but the likelihood of you being able to get it back, there's a strategy there that's different from trying to prove the need, because you've already proved the need before. You got protective supervision in the past. And so if you already did that in the past, then the burden is now on the county to disprove it rather than if that makes sense. The burden of proof is shifted. If you don't have protective supervision or you don't have the level of hours you think your child or loved one qualifies for, you have the burden of proof to show that they need it. That is far more difficult to win at that higher level and keep it going versus already having it and then having a judge. So I'm really glad that you had a judge that saw and recognized that that was your situation, and didn't let the social worker just kind of willy-nilly take hours away like they did. Right. And definitely not taking away anything from you by saying that like one hearing is like harder than another, because they're all going to be extremely difficult to go in front of a judge, because these are still state, law judges, administrative law judges. Right. But thank you, Bobby, for sharing that. And it looks like we have a lot of people who are sharing.
I'm going to skip ahead a little bit and say, so Rebecca's asking then, why bother appeal at all? Who's the system for? It's just me. It seems like an adversarial system when it absolutely should not be. Absolutely. So why don't we jump into some of the things you should and shouldn't do for when you are going to appeal. You've decided, okay, there is a good reason. The county was definitely wrong and you think you can prove it. What are the things we should and shouldn't do? Let's jump into some of those things.
Yeah. So what you shouldn't do, we'll start with that, is filing for the appeal prior to the preparation, right? I think that's a pretty elementary way of saying that.
Like, don't rush into it, because you do have a lot of time.
Yes. And I know that that's easier said than done, especially when this is maybe your financial livelihood, right? If this is with paying your mortgage and all of a sudden $4,000 a month now is being ripped away out of nowhere, right? Or maybe you can't work a job anymore, and that's the whole point of why you're applying for IHSS. And so we get that there is like a timeliness, point there for most people, but when you appeal, the more time you have, the better chance you will have at preparation. The better chance opportunity you'll have to talk with other people who have done it, or talk to experts, advocates, lawyers, maybe not hiring anybody for support, but at least getting that feedback, right? Coming across streams like this where we can talk about it. And so having more time is better normally.
I'd say the one big caveat to that is if you've had a large number of hours taken away,
True.
then you have a very short period of time to ask for aid paid pending.
True.
So if that's necessary, that you want to that you need to continue getting your hours that you were already given. Again, this is only for when you've had them taken away.
Yeah.
If you never had PS and you got denied, aid paid pending doesn't apply.
Yep.
But if, in a case like Boblin mentioned, if you lose PS, then you have a very short amount of time to ask for aid paid pending to keep being paid while you're waiting for your hearing.
Yeah. And we could talk more about aid paid
Yeah.
pending if you guys have questions on that.
But to clarify what he was saying, once you get your notice of action, you have 3 months before you have to request a hearing. And sometimes that's a great time to seek out representation, get an advocate or a lawyer to work with you, or to get more documents from doctors, from the teachers. I mean, right now, people are going to hearing, and you might want documents from teachers, but it's summer, so you might not be able to get in touch with them. So that extra 3 months that you can wait before filing is time that you could spend either getting in touch with these people who are out for the summer or getting meetings with the doctor, because that could take a while. And like I mentioned, getting an advocate or a representative, because we always advise doing that when you're going to go to an appeal.
Yeah, especially for something like protective supervision. Unless you are equipped to understand, or not understand, but like spend that time and energy reading the regulations, because that, excuse me, going back to somebody else's comment here who said basically like, what is the point of appealing, right? That was Rebecca. Rebecca was like, why even bother, right? Obviously, you should. If it's needed and this person's wrongfully denied something like protective supervision, you should appeal. But what we're saying is you can't appeal it and expect your words to hold much weight. You have to have certain things in place in addition to making sure the assessment goes a certain way. So if the assessment goes a certain way where the social worker is able to utilize regulations and their testimony paired with their observations in an argument, that's going to make for a really difficult case to fight against, even if it's wrong, even if a lot of what they say is just not accurate. And so that can be really tricky when you're not prepared for that prior to the assessment. So if you have a witness, an advocate, or somebody, or yourself, know what to look for, what to say, maybe what not to say, questions to avoid answering, because you know the social workers aren't supposed to ask those questions, right? These are all little things that lead up to kind of the big picture here of what can make the appeal worth it, rather than a big waste of 3 to 6 months, because it could be longer than that.
I think that kind of leads me to one of the big points we wanted to make about what not to do is, if you're going to have someone join you for the appeal, make sure it's very clear to them what the message is that you're trying to get across.
Yeah.
What it is about, if it's for your child, what it is about your child that you want them to talk about. Because sometimes, you could get a school teacher to come in and speak at the hearing. That's great. That's very helpful. But if they don't understand that the purpose is to talk about the child's unsafe behavior, their elopement, their non-self-direction, then they might come into the appeal and want to start talking about their math skills, or how if they know their alphabet. And that's not going to give the right impression. It's going to kind of derail the hearing in a way that's not helpful. So we've seen times where someone was brought into the hearing to testify, and they didn't really understand the purpose of trying to get protective supervision. And so they were talking about how great the child was doing, how much better they were growing and learning, and all these things. And it was really hurt the case.
And this could be as simple as another spouse, the other parent, right?
Mm-hmm.
Where you as one parent have been working really hard the last several months, kind of preparing and building, learning what you can, watching our videos, watching videos from other support groups, and reading the regulations, and you've got it nailed down. You're like, okay, cool, this is my argument. And now you invite, your husband along, or your spouse, and they join you in for the hearing, but they did not do that prep work. And so they weren't watching the videos of what to avoid. They weren't talking to other people and learning about these experiences. So then they do exactly what Dakota said. They start talking about things that don't relate to the point of protective supervision. And in fact, they might say things that are the opposite, right? One of the big points that we have that we prepare a lot of our clients for, or right before we're about to go into a hearing, is to kind of leave emotion at the door as best you can. You're no longer, if you're going in front of the judge, you're not representing your child. You're representing your client. This is not, mom or dad and child or loved one.
Mhm.
This is caregiver and recipient, caregiver, patient, client, right? And so when you're able to do that, you can separate the emotions from it. Easier said than done. But when one parent comes in there full blown saying, you know, my spouse works so hard to take care of little Timmy. He's such a difficult child to work with his autism and blah, 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 blah. You don't understand that right there. Your hearing is going to go south because the judges don't care about those things. They just care about what are the facts here, right?
Yeah.
Again, I know kind of like a simple way of putting that, but still
Now,
very important.
You remember back when we went to a training, me and Caleb did, with a bunch of the hearing reps from the counties, and they did some example hearings, some sort of mock hearings, and it gave us an idea of the impression they get from when a parent or a family member is there, is that they assume that you're going to be emotional and irrational and not understanding the program. And so that's why we want to say, you want to come to this from as objective as, you know, look at this case as if you're a lawyer, as if you're an attorney, and be, you know, passionate but not emotional.
Yeah.
Right.
I agree. Yeah.
Which, I mean, is easier said than done, right?
Definitely.
Yeah.
Absolutely. Especially like I was saying earlier, sometimes judges will say some things, or even social workers will say things, or an appeals rep will say certain things in the hearing, and it just bothers you. It rubs you the wrong way. And you're like, God, why would they say something like that? Sometimes those statements or those questions are planted to get you ruffled.
Mm-hmm.
And sometimes it's on purpose because they know you're going to say something that's just going to kind of blow everything up. Other times it could be a tactic of the judge because they want you to clarify. They want you to argue in a way that's helpful for your client, right? And so you just have to know in those moments, like Dakota said, easier said than done, not being emotional, but objective, as much as objective as you can.
Mm-hmm. Which actually, that I wanted that kind of reminds me of something else we want to talk about, which is one of the most common questions that you'll get from a judge during a hearing is, and this is about protective supervision,
Mm-hmm.
how often does that behavior happen?
Yep.
All the time. They will ask that about every single thing you talk about. They will want to know, how often does it happen? And some of the worst answers, what the judge never wants to hear, is an answer like many times, often, all the time, every day. They don't like those answers.
Yeah.
They want something more specific. They want to hear almost every day, 3 to 4 days out of the week happens once a day, right? Or they want to hear between 2 to 5 times per day. They want better numbers than all the time often. They will get so mad at you if you start saying things like, oh, it always happens.
Mm-hmm.
They hate that.
And we know how difficult it is to quantify something like that, right?
Mm-hmm.
Because you're not used to just counting on a chart. Oh, little Timmy, he eloped again. Hang on, before I go grab him, I need to write on the chart. Eloped. Okay, hang on, little Timmy. Like,
Mm-hmm.
obviously, we know that that's not the reality of the situation. But Dakota's right. Numbers are very important to social workers. They're very important to appeals reps, and they're very important to judges.
Very, very, yeah.
Because this, like, many, whatever. I mean, now also a point to make out. If you say, you know what, I've been keeping track of this, I've gathered it. You could say it's really hard to quantify.
Mm-hmm.
Sometimes we have better days than others, but I would say on average, I'm looking at, maybe a couple times a day, 2, 3, maybe 4 times a day, I will find little Johnny, little Timmy trying to elope. Now, if you say that, that's great. The judge is getting what they need, the data that they need. Now it needs to be backed up with something, right?
Mm-hmm.
So if that judge turns to evidence that you've presented or the social workers presented, like the IEP, and the IEP says little Timmy's only attempted to elope from school once in the last 3 months.
Mm-hmm. Or if it says at least once a month, but not every week, or something along those lines. Because the IPP and the CEDAR from Regional Center, they say things like that.
Yeah.
They'll say, not every day, but at least once a week, or, at least once a month. And so if you suddenly get in there, you say multiple times a day, well, that's going to be a problem.
Right. So if you say something like, oh, it happens at least 2 to 3 times a day, sometimes it could be more. Sometimes it can go 5, 6 times a day, depending on if it's a bad day or a good day. The judge is going to want to know, how did you get that number? That's great that you're giving me this number. How did you get it? Right. And you can say, oh, I've been keeping track of it with a log, right? You can do that. Absolutely. But you do have to remember that the judges are going to put a lot more weight into the evidence that is not coming from you, but people who care for your child, the experts in the field, right?
Yeah.
Um,
Now, what does come from you, and here's the thing, while you're right, it won't be given a whole lot of weight. If the evidence that comes from you contradicts itself, then it'll be given a lot of weight in the opposite direction.
Yeah.
Because the judge isn't just going to have what you're saying during the hearing. They'll also have anything you wrote down beforehand, anything you told other agencies beforehand, and what you told the social worker at the assessment. So if at the assessment you said one thing and then at the hearing a few months later, now it's changed, they'll need to know, okay, was there a big change in the person's behaviors between then and now? Or are you just making stuff up because the first time it didn't work?
And this conflicting evidence kind of goes in line with what Cindy's saying here too. My son had protective supervision taken away because his worker saw in his IEP that he doesn't elope. So now he gets 33 hours a month. On his next assessment, can more hours be taken away? So again, hours are going to be allotted or removed based on the level of need. So with protective supervision, clearly they took that away because they did not see that elopement was being reported in the IEP anymore, right? So one of the many ways you have to be prepared to know that these documents are going to change year by year. You have to be ready that when you get a new IEP, it's going to include certain things. Little Johnny may not be eloping at school much anymore, but does that mean that behavior is no longer a concern? Because if it's still a concern, then the school has to make note of that. And if you don't tell the school to make note of that during the next IEP meeting, they're not going to, right? So that's one. And I'm sorry, Cindy, by the way, that's really awful that they took protective supervision away, especially if it was a wrongful removal of it. You are more than welcome to call our office. I think we might have spoken with you before, but reach out. I'd love to see if we can try and help you. Dakota, should we try and get through a couple of questions? Because I think
I think there is some even before that. I think
I might have missed
this one.
Oh yeah.
Can the social worker verbally deny your 3-year-old PS? I asked for PS and she said she's going to deny him, but still has to give me the PS form. Even if I give her the form, she's denying him still. Give her teacher statement, ABA statement, progress report. Said she's denying him based on observing him. Flip a book for 45 minutes, and he's 3. It's a parent's responsibility. His cognitive level is 2-month-old. She said she did AB in the past and very familiar with autism. Well, I mean, what that says to me, they can deny. It's their job to make an assessment and approve or deny. But what that says to me is that she made her decision, very clearly without even looking at any of the evidence, even before receiving the evidence.
And a lot of people
she's telling you of her decision.
A lot of people will say, hey, I got denied at my assessment, but I feel like the social worker denied my case before they even saw my child.
And what's that? That is denying based on age. 100%. Right? Because anyone, if your child was 5 or 6 or 7, well, now she'd be waiting for the forms before saying she was denying. But because he's 3, she's saying it's parental responsibility. They can't do that. They cannot deny protective supervision solely because of a person's age. And it seems to me, based on what you're saying, that that's what she's doing. Yeah.
And so we're sorry that happened. We're hoping things can be made right. Hopefully maybe through an appeal or at another assessment or, applying again. Either way, you are more than welcome to reach out to us. We'd love to see if we could try and help you. Veronica, IHSS worker is very late for annual appointment. What can I do? I called and left voice messages. Well, if you are in need of an assessment because you feel like there's been a change, that you need an increase of hours, you can write a letter. You can fax something to the county, call and try and speak with a supervisor. That's if you are in need of an assessment. If you don't feel like there's much of a change since the last assessment, I would say just let it ride, but kind of up to you, to each their own.
Stella said, so hours, even PS, can fluctuate, but one can't grow out of IHSS, correct? There's a few things here that I want to tackle. One, you can't grow out of IHSS. That is true. Now, if the needs change to such an extent that they no longer need help with any tasks, well, I guess you could, grow out of it in that sense.
That's a celebration.
If the whatever disability, whatever impairment led to the need to IHSS completely is mitigated, completely removed, then you don't need the. But age-wise, there is no point at which you're 18 now, or you're 25, or you're 60, you can't get IHSS anymore. Now, talking about the hours fluctuating, setting aside protective supervision, the other hours, it's very normal for them to fluctuate. A little up here, a little down there, a little less bowel and bladder care needed, a little more feeding, not as many, medical appointments. That's normal. Protective supervision shouldn't really fluctuate. If you get protective supervision, the amount that you get is always the same. It is always 195 hours a month, 45 hours a week. The only difference is if you hit the maximum cap of 283 hours a month, then they'll lower the protective supervision so that you can get the other things. So that you can get the bowel and bladder care and the dressing and the paramedical. And they'll lower the protective supervision just to the point where you're at the cap. That way, if you lose some bowel and bladder care, your protective supervision will increase to make up the difference. Sorry, I know it's distracting. I'm getting a whole bunch of messages on my phone. We're going to ignore that. So that's the only way that PS should fluctuate. Most people who need protective supervision will not suddenly lose it, suddenly gain it year after year. That's not normal. Because people who have mental impairments such they don't understand danger, that doesn't usually just go away overnight. Mm-hmm. Like 1 year to the next, that is not usually supposed to change.
Yeah,
Anything you want to add to that?
Well, exactly your point, right? Protective supervision is for a very, very high level need of person who requires constant supervision. So if you are cognitively at a point mentally ill or mentally impaired where you need that constant 24-hour supervision, it's not likely that condition that you have is just going to change, right? You don't grow out of something like autism. You don't grow out of something like Down syndrome. They can evolve as the child grows and ages. And then same thing with like an elderly person with dementia or a mental illness that can only be progressive, right? Or can be, I guess. But the point is to say that if you got protective supervision 1 year, odds are you're probably going to have it for a while or should qualify for it for a while. But it's not going to fluctuate. It's not a tiered category. So you're not going to have some of the protective supervision or a lot of it. It's either all of it or none of it at all.
Yeah.
Right. Okay. So Boblin mentioned that the judge actually criticized the people from the county. So Boblin,
you can probably guess which judge that was.
So
there's only a couple good judges really that will actually take the county to task.
There's 26 slots for judges, 26 judges. I don't know if all of the slots are filled at the moment, but most of the judges that we see are not necessarily ones that we can picture criticizing the county. But there is a couple that we know that are actually really, really decent judges. Mm-hmm. And so I'm guessing you got one of those judges, which is awesome. I'd say the likelihood of that it's not common. It's definitely not a common experience for a judge to kind of rip the county apart, because the judges, again, they're there to sort of like authenticate the social worker's opinion, the appeals rep. They're the expert in this field. This is their benefit, right? And who are you to say that they're wrong? And so that's kind of the experience that we see a lot, and I know a lot of people do. But Boblin, awesome. I'm so glad to hear that things were made right. There was justice there. And hopefully these social workers and county people can adjust. All right. So real quick, thank you so much for all the comments, everybody. We do have maybe some more points. Let's talk a little bit about maybe, I say we should go directly to like pre-hearing conversations with appeals reps.
Okay.
Maybe some things to avoid. What are your thoughts?
Okay. So this is something that maybe some people aren't expecting when they first ask for an appeal, is that you'll get a phone call from somebody from the county. Now, this is where it can get a little bit tricky.
Or a letter.
Well, you'll usually get a letter, I think, first introducing who they are, and then they'll follow up with a phone call at some point after that. There is the position, aside from the social worker, because there's social workers, there's their supervisors who are usually involved in the decision making. And then when you ask for an appeal, you'll get in touch with the hearing representative from the county. And this is essentially, if we were to think of this like a court case, like if we as advocates are the defense attorney for you, then the appeals rep is basically the prosecution attorney for the county, right? They are essentially your adversary, your opponent in the hearing.
But they're the advocate.
And I don't mean that as in a bad way, as like, oh, they're the bad guys or whatever. But if you are the claimant, they are the defendant, So they are your opponent within the hearing. However, we've had many times where our clients who were already working with, who already knew that they were going to receive contact from the county, the way the county representative introduced themselves gave them the impression they were talking to an advocate like us. So the county representative would call and they'd say, "Oh, I'm a hearing support person, or a mediator, or a helper," or even they called and said, "Oh, I'm your advocate for the hearing."
That's my favorite one.
And which is insane because, like we were just saying, they are essentially your opponent. This is the person who's going to be arguing against you during the hearing. And when we tell our clients this after the fact, they give us a call and say, "Hey, I got this call. I thought it was you guys that called us, but then we talked about IHSS and talked about our case, and they asked a whole bunch of these questions." When we tell them, "Hey, that's the person who's going to be arguing against you, saying that the county was right in all that they did," our clients are blown away when they find out that, because the way that they will introduce themselves sometimes is incredibly deceptive. So be prepared for that.
Yeah, and we're definitely not speaking of all appeals reps, because again, the job of the appeals rep is to technically be a mediator. Their job is to try and get this resolved without going in front of a judge. And so, yes, if the social worker made a mistake and they wrongfully denied this person protective supervision, it is up to the appeals rep to determine that. The challenge we see is that a lot of appeals reps don't want to overturn a social worker's decision. They don't want to step on social workers' toes. And sometimes they just have no interest in wanting to help you, but rather help their colleague, the social worker, right? And so that's what can be really frustrating. Now, again, that is not all appeals reps, but we do know quite a few, probably way more than the other, right? So just know that, like Dakota said, when there is an opportunity to speak with an appeals rep, there are some things you must consider and avoid, right? So one of the conversations we had is about conditional withdrawals. So when you file an appeal, the terms here are a little confusing. Appeal, hearing, right? So a hearing basically is a result of an appeal. You request an appeal, that's the dispute. The hearing is one of many results. So besides a hearing, if you end up meeting with this mediator person, the appeals rep, and they don't want to go in front of a judge, maybe you have a good case, but they don't want to say that. What are some other outcomes besides a hearing? Well,
one of the main ones, well, of course, the opposite of going to a hearing, having your case heard by a judge, is just withdrawing the case completely. Like, that's sort of the opposite. That means you're giving up any claim that you had that of anything, and you just want to not have the hearing. You just withdraw it. That is not usually preferable. Usually you want to come to some kind of agreement, some kind of arrangement. And that's when you do what we oftentimes will push for, which is a conditional withdrawal, meaning us and the county have come to some kind of agreement. They'll do their part, we'll do our part. And maybe that means they're going to grant the hours. Maybe that means they'll reconsider, reassess. Maybe we'll get them some new documents, and upon receiving those new documents, they'll make some kind of change.
It's kind of like a settlement, right? So if you're being wronged by a business partner and you hire a lawyer to sue that partner, and that partner gets their own lawyer, and then the lawyers, they don't want to go in front of a judge over this. So the lawyers come together and they're like, "Hey, maybe we can strike a deal, right? And get this settled." That's kind of like what a conditional withdrawal is. You're withdrawing based on certain conditions.
And if those conditions aren't met, then you can reopen the appeal and go to a hearing, just like you were planning to do originally.
Yes.
So if the county says, "Oh yeah, we'll within 30 days," because you pretty much always have 30 days to complete the terms of the withdrawal. We'll say within 30 days, we're going to reassess and we'll release a new decision, maybe granting more hours, maybe not. Well, if they don't complete their assessment, if they put it off and say, "Oh, well, we don't really care," then you could just say, "Oh, well, 30 days have passed. We're going back before the judge."
Yeah, and the judges won't like that. Judges will not like that you had to reopen the hearing. They won't be mad at you for that.
Yeah, exactly.
They'll be mad at the county. They'll say, "Why didn't you
not completing their job?"
Yeah, you didn't complete the order, right, of this conditional withdrawal. Now, when getting to this point, if you do have a solid case to present and you're able to convince the appeals rep, maybe you request it. Maybe you say, "Hey, you know what? What do you need? What do you need to see here to show that this person needs something like protective supervision? Would it be another assessment? Would it be more time to gather documents? Because if so, I'd be happy to agree to a conditional withdrawal. where it states those things. Send the social worker back out. I'll provide them with more information. I'll provide clarity on some questions that you might have as the appeals rep. But what you don't want to do is agree to this conditional withdrawal without understanding and knowing the conditions beforehand, right?
Yeah.
Now, in the past, I don't know if they do this much anymore, but a lot of times appeals reps would get you to agree to a conditional withdrawal over the phone, not written. Now, that is a no-no.
I think I still heard this happen at least once recently. Yeah.
So I would never sign a conditional withdrawal verbally with the appeals rep to avoid the hearing. If they are offering a conditional withdrawal to where they can reassess you or give you more time to gather documents, make sure you ask for that in writing. Send it in an email or mail it to you so that you can read the conditions, because sometimes those conditions will not be what you agreed upon on the phone. Right.
Let's one of the most common issues that sometimes come up on conditional withdrawals is, I'm going to make up a hypothetical situation. Okay, so let's say you applied in July. You applied in July and took a couple of months for them to come out and do the assessment. Maybe they did the assessment in August or October. They did the assessment in October, released their decision in November. You weren't happy with it. You filed for an appeal. Couple months later, you get the appeal. It's January now. You talk with the hearing rep, and they're like, "Oh, I think we can come to some kind of agreement. We'll take all this new information you sent us. We'll do a reassessment, and we'll release a new NOA." You're like, "Okay, great. Now we'll go for those kind of deals all the time." But it's important that you get it in writing, because in writing it'll say what the effective date, or it should say. If it doesn't say, you need to get that added.
Yeah, because sometimes everything else might
right. Say, maybe if everything's all good, it'll say, we're going to come out, we're going to do a new assessment, we're going to release a new NOA, and whatever the change in hours will be effective, July 15th, back when you first applied. Or it might say, all the new hours are going to be effective March 1st. And you're like, well, hold on a second. I appealed the decision they made from way back then. Mm-hmm. And if you sign it, you agree to it, and they do it, that's your contract. You agreed to that. And so all they have to do is they just make a new decision, write off, and you've basically lost your ability to appeal the previous decision they made for that whole last year. So you could lose 9 months of potential protected supervision hours just because the condition withdrawal, the effective date wasn't what you were expecting.
All very confusing, intimidating stuff. Don't be afraid to call for help. We'd love to hear about your situation. So if you are filing an appeal, or you're trying to maybe pursue that or consider the options, we'd love to try and help you. Yeah. And thank you to everybody in the comment section, by the way. I'm sorry we have not been able to address everyone. We do have a few minutes left. Dakota, do we want to
try and jump through some of these questions real quick?
Them? Yeah. So let's see here.
I don't think that's a question, but we can... If you have any last minute questions, go ahead and throw them. We're going to try and get through these really, really fast.
Thank you, everybody, for being here.
So a lot of interesting stories here about people who've got their...
Yeah.
There was some talk about conservatorship. Do we want to talk about how conservatorship affects an appeal? Because it can be a little bit tricky.
Let's talk about that in a moment. Patricia, What about impulsive behaviors where we cannot predict what dangers she will put herself in? Well, that would be one of the many ways you would describe somebody as non-self-directed, right? If they engage in a dangerous behavior and you don't have all of the triggers nailed down, it's not always predictable. Maybe sometimes it can be, but other times it's not. Then, we would blame that behavior as a manifestation of the disability, right? If it's just a behavior because it's just what a typical kid would do at that age, then it's going to be not related as a maladaptive behavior for the purpose of protective supervision, but rather just a typical kiddo misbehaving, right? But yeah, if it's something like eloping where they're constantly doing it, or it's self-harming tantrums where they slap themselves, bang their head, and that, yes, sometimes they'll do it when they're upset about something, like you take a tablet away, or it's during a transitional period. But other times it can be on a good day and you're like, oh my gosh, I did everything right. How come we still ended up with a meltdown today where my child hit themselves, right? If that is your situation, then yes, that is a behavior that goes in line with the regulations for what is considered non-self-directed. Therefore, protective supervision criteria, right?
Yeah.
Okay, so Dakota, you were mentioning conservatorships. There was I think Boblin had mentioned something. But why don't you go ahead and share your thoughts on conservatorships and how that plays a role when appealing?
Yeah. So what we have found is that when you are filing for hearing for an adult who is not conserved, this can sometimes cause some unfortunate problems within the hearing space. Now, it is incredibly problematic if you are the caregiver for someone who is not related to you, and they may, this could be an elderly person. They might have dementia or Alzheimer's or schizophrenia. And you're appealing for protective supervision on their behalf. If you are not related to them and they're not conserved, this can completely take away their ability to even have a hearing.
Yep.
We have had cases in the past where a caregiver, is trying to help out this person. He clearly needs protective supervision. He's got dementia, but because he wasn't conserved, she couldn't represent him at the hearing, and she couldn't have us represent him, and he couldn't have us represent him because he wasn't mentally able to sign our contract to have us as his representatives. And so it was basically him, even though he wasn't mentally able to understand what was even going on, he either had to represent himself or he just couldn't have a hearing at all. And so he basically lost out on his rights to have a hearing because he wasn't conserved. Now, when you are the close relative, especially the parent or the child of a person going to hearing, and they're not conserved, most likely, if the judge, sees this person, hears about them, and determines that they're not mentally able to represent themselves, usually the judge will temporarily allow their family member to be their representative. However, we several times have had it that even though the family member, the parent, or the child was allowed to be the representative, they would not allow that parent to have an advocate. Now, legally, we think that there's maybe some issues to that. Maybe that could be challenged, but in the moment, there's nothing we could do about that. And so this parent basically had to represent their child without any help because the child wasn't conserved, so they couldn't hire us, and the parent was only the temporary representative for the child, so the parent couldn't hire us either. And so we were disallowed from taking part in the hearing. So these are some of the struggles that can happen when you have a non-conserved child. And it's
adult child, by the way.
Adult child, of course, yeah.
To be clear.
And if you're already representing the child yourself, it might be fine if the judge allows it. But if you're trying to get an advocate or something like that, it can be very problematic.
Definitely. And if you're wondering if a conservatorship is something that you should consider, I would highly recommend reaching out to a family law attorney or an estate planning attorney who specializes in conservatorships. Do a little bit of research on it. It can be life-changing and can really support an individual who would benefit from something like that. I know my siblings who are profoundly disabled all have conservatorships, and it is necessary. And so because they are conserved, my parents who care for them don't ever have to worry about speaking on their behalf. They're conserved. My parents can speak on their behalf, do pretty much whatever they need to do to keep them safe without considering, their because of their inability to understand safety, medical choices, financial decisions. My parents have that peace of mind of knowing that they can protect my siblings in that way with the conservatorship. Same thing if they were to ever have to go in front of a judge, right?
I'm going to jump around here. I saw that Janet had a really good question that we probably want to tackle. Said, my son recipient is 12 years old. We recently had the yearly assessment. We have PS, bladder, dressing, hygiene. But I noticed we don't have any related services: meal prep, meal cleanup, routine laundry, shopping, errands. How do I ask for hours
I want to
for
answer
these services? Of course you do.
Just kidding. I know something. Just kidding.
Go ahead.
So great question, Janet. So those categories you just brought up for related domestic services typically are going to be reserved for bigger kiddos or adults. Mm-hmm. So those are all considered that parental responsibility, kind of that line that somebody else had mentioned earlier too in the comment section. So parental responsibility, spousal responsibilities, these are things that can impact this person's eligibility for those tasks. So for things like specifically meal prep, meal cleanup, shopping for food, and the other categories like the hazard ones, cleaning the house and doing all that stuff.
Domestic.
Yes.
Yeah.
So those typically will not be assessed until the person is 17 or 18 years old, because they have to assume that your 12-year-old probably wouldn't know how to prepare their own meals or clean up the house or do their own laundry just yet. Now, laundry can start at around age 14.
Yeah.
So 14 is usually when a social worker from the county is willing to assess for that. But for meal prep, meal cleanup, they don't typically grant that task until about age 17, unless there's an extraordinary need. So if there is if there's an additional challenge or many challenges for that task because of this person's disability or diagnosis, like for example, if let's just say your child has diabetes, or they have extreme, dietary restrictions where it requires you to prepare their meals way differently than you would a typical child, where it takes hours and a lot of research and a lot of care to make sure they get their food safely, that could be considered an extraordinary need.
Yeah.
Or it could be something simple like fed through a G tube, or a special type of feeding where you have to puree all the food and XYZ, but that could also be like
it could be paramedical. It depends on the situation. Another common one is for laundry. Like you mentioned, laundry typically isn't given until 14 years old. However, oftentimes, like you mentioned, you have bowel and bladder care. Sometimes if a child is receiving bowel and bladder care and it's to the point where they have frequent accidents, they soil themselves, they have nighttime issues on the bed, if that results in 2 or 3 or 4 times more laundry than what you typically would have to do, then that is one area you could get exceptional need for laundry. Not because the need is necessary. Well, not because each time you do it, it's harder, but because you're having to do it 3 or 4 times more often than usual.
Yeah.
Right. And then the one category, the domestic chores, housekeeping, yard work to remove hazards, those, there cannot be any exceptional needs for those. You absolutely cannot get domestic chores until they're 18 years old.
Yeah. Hopefully that answers your question, Janet. Thanks for being here. And we are just about out of time. We know Nicole should be going live in Spanish, right, Teresa?
Yes.
If we get out of her way.
In about 10 minutes or so, probably.
Okay. Well, it should be 5 minutes.
5 minutes. Let's tell her.
1 o'clock. Thank you, Dakota, for joining me today, allowing me to come to your territory again, the office. Thank you, everybody, so much for tuning in and asking some great questions. Hopefully this helps you with some peace of mind if you're trying to appeal or just learn more about the process. We really wanted to give you some tips on certain things you can avoid. We also would highly recommend that if you're going to consider appealing, consult with a professional. You're welcome to reach out to our office. If you watched this stream and thought you don't like us, call somebody else. There are other advocates. There are people who do this for a living, who know all the ins and outs of the appeal world. So it would be really, really important. I would recommend that you talk to somebody who understands this process really well, and they can give you these pointers, maybe a little bit more formally, a little bit more detailed, specifically to your situation. Yeah. Because a lot of what we said is very generic bullet point type stuff.
As much as we want to give advice, we want to help people, kind of get on the right track. Ultimately, we never recommend doing hearings on your own. If you can avoid it, we always think it's better to have help from some kind of professional. Like I said, it doesn't have to be us, but I would say it's very rare. Boblin's been great in the comments to answer a lot of people's questions about their situations. But it takes a rare person to know all the laws and knowing the right way to argue and what's, be able to look at cases very objectively, because it's easy for us to say, well, this isn't going to help your case. That's not no good or whatever. But when it's your own child, it's really hard to look at these things from a purely, objective, cold, emotionless perspective. Yeah. And so, we always advise seeking out advice.
100%. Yeah. Absolutely. All right, everybody. I think we're about there. Thank you again so much for tuning in. Great questions. Hopefully you liked this topic. You're welcome to reach out to us by either calling our office, emailing us, or messaging us here on Facebook or even YouTube, right? Because we're streaming to YouTube.
That's right.
If you want to get connected with us, contact us. We'd love to see how we can help you.
We got starting soon.
And we got a Reddit page starting soon.
No, I think we might start posting on the IHSS Reddit from time to time. So we
I
might.
So
like it.
we might open up our own Reddit and then maybe
We're trying to expand and let as many people as possible,
benefit
from our expertise. Yeah.
There you go.
Beautiful. Love it. Well, thank you again, everybody. I hope you all have a wonderful Friday. I hope you all enjoy your weekend, and we will see you next time.
Bye bye.